I welcome you in my 10th lecture relating to legal compliance for incorporating startup, and I am in the module of incorporation of partnership, LLP and cooperatives, and more specifically I will talk with you how to incorporate a cooperatives. Now, in my last lecture I have talked with you the law relating to the cooperatives, and therein I have mentioned that in generally the cooperatives need to be incorporated to promote some kind of a social cause. So, there should be some kind of a social and economic objective for the betterment of its member, and it should other way around help the people to develop in that particular local area, or whatever the way they want to do. So, if you wanted to incorporate a startup which is relating to social innovations, or which is going to provide some kind of a social infrastructure, or which is going to sort out some of the issues relating to the financing, social financing, so much so forth, then it is always advisable that you should go for the cooperatives. Now, as I have told you in my previous lecture that cooperatives give you a lot of flexibility as organizations, but as well as it gives you a firmness because it is a body incorporated. That means the cooperative itself, a person in eye of law, this is more of a technical legal connotation, but it means that even if there is a change in the member, or some member comes and goes, there is a no change in the cooperatives. At the same time, there is a no change in the assets of the cooperatives or liability of the cooperatives. But you need to decide while you are incorporating that what kind of cooperatives you are basically promoting. Are you interested to promote limited liability cooperatives or unlimited liability cooperatives? Now, in this particular lecture I am going to talk more about how to frame the bylaws, but before that let me tell you there is a certain procedure which is prescribed by the state legislation which provide the governing laws relating to the cooperatives, and you need to file the designated form which is prescribed in that specific state legislation. I am not going to name those particular forms because it is going to vary according to the state. So, you need to find out that which are the forms you need to fill up. But what is the most important thing is that after filling up all the forms and requirement, you need to create a bylaws. Now, one thing I like to draw your attention that incorporating the cooperatives are little less costly than incorporating the other form like even LLP also, because the state like to promote these particular cooperatives, and state promote these cooperatives for a different reason, like it can be for the social help, or maybe self-help group, or maybe some of the social cause, or for some reason. So, what the state did, they kept the compliance cost quite minimal in compared to other form of business organization. So, if you have less capital, but you have a great idea, and if you cannot have expertise to go for a lot of compliance, then this particular organization is good for your startup. Now, you need to identify the cooperatives, and while you are identifying the cooperatives, you have to give a name, address, registration number of the cooperatives through which the people can identify a particular cooperatives. So, you have to have these particular provisions made into your bylaws, and then you need to have a custody and use of the common seal. That means, who is going to keep this particular common seal? Common seal, the moment you are putting the common seal, it indicates that the cooperative is giving the consent for that particular transaction. Now, please remember the cooperatives as an artificial body or legal person, whatever I have talked with you, cannot give the consent by its own. So, there will be some group of people who are going to give the consent on behalf of the cooperatives, and that particular group of person might be the directors, or maybe the board of directors authorize the CEO of that particular the cooperatives or managing director of the cooperatives to put the consent. So, there should be some kind of a designation created, or some people will be designated to hold this particular seal, because the moment you are putting the seal, it indicates that the cooperatives are giving the consent to this particular action. Then you need to talk about the area of membership, like cooperatives might be limited to a geographical location, and then you can define that the membership should come only from this particular geographical location. Next important thing is that talking about the objective and services which this particular cooperatives is going to provide, and in that particular process you need to talk about the common central need of the member which the cooperatives aim to fulfill. That means, to somehow you need to define the objectives of the cooperatives, but this particular objective is much more flexible than that of a company's objective, or the objective which you have provided in LLP or limited liability partnership. So, you need to have a broad definition. One of the good issues in case of the cooperatives is that the ultra virus concept, which is very stringent in case of the companies, are not stringent in case of the cooperatives. So, in case of the cooperatives, it is more flexible in nature. Now, you need to talk about the principle as stated in the Act. According to that, cooperative should conduct is affair. And if you remember, in the last lecture I have talked about the principles are generally that the cooperatives has to promote for the social help, cooperatives should promote the social objective, so much so forth, or it should promote the objective of the members or the community where the members belong. Then key service and support which this particular cooperative want to provide, the condition under which the services may be provided to the non-member also, you can provide the provision relating to that. Then the important thing is that capital and the fund, because if you wanted to carry out the business, then you should have adequate provision relating to getting the fund, how to raise the capital and how to utilize the fund. And you can decide on the nature and amount of the share capital, if any cooperative, and the manner in which that capital can be raised, and what are the type of instrument these particular cooperative can issue. So, you might talk about the equity, and if you are talking about the equity, what are the nature of the equity, do you want to create a class within the equity, all these particular thing, or what is the face value of this particular equity. Will you like to add a premium if you wanted to subscribe the equity later on. So, all these particular issue you can add with this thing. Now, you can talk about the maximum capital a single member can subscribe, because as I told you, even the law also limit that you cannot subscribe more than 1/5 of the total capital, or even sometimes they might prescribe even the lesser limit than that. So, in the bylaws you can specify further, you can give a lesser limit, because you cannot exceed if there is something which has been provided in the law, or whatever the provision has been provided in the law, you can put it down, but you can give a different kind of the limit into this particular thing. Then you can talk about the nature and extent of viability of the member for the date contracted by the cooperatives. So, what are the kind of date they can take, what are the policy of lending the money, or what are the policy of borrowing the money, you can detail out in this particular thing. Then the source and the type of the extent of the funding to be raised by the cooperative, that you can talk about. And most of the cases, as I said, that you cannot go for issuing of the shares into the primary market as a public listed company can do. But in case of the cooperatives, you can add a new member, and the new member can bring the subscription. At the same time, you can go for different designated state institutions who can give you the money for carrying the business. In fact, you will find the terms of lending the money in case of the cooperatives is much easier or much soothing in compared to other organization, or there can be some kind of a dedicated institution created by the state or by the central government who fund these cooperatives, and accessing those particular fund is easier than other organization. Now, you have to talk about the extent and the condition under which the deposit, loan, debenture and the other fund may be mobilized. So, the cooperatives can take all these particular thing. They can raise the deposit, they can raise the loan, they can issue the debentures. I believe you are aware of this particular thing. These are basically the credit instrument, and deposits are whatever we are mentioning here. These are basically term deposit. Term deposit means it is different from the demand deposit. Demand deposit means whatever we are habituated in case of the bank. That means you can go to the bank, even if you have a fixed deposit, you can any point of time liquidate. But when we are talking about the deposit in case of the cooperatives, is that a term deposit. That means before the term or before completion of the term, you cannot liquidate this particular deposit. At the same time, there can be a debenture kind of an instrument which or the bonds which this particular cooperative can issue, and they can have terms and condition of issuing these particular debentures. So, debentures can have a fixed rate of interest, and it can also have a period after which this particular debenture will be redeemed by these cooperatives. The condition and the purpose for which state aid and aid for financial institution may sought or for the obtain. And as I told that in generally the state facilitate a lot to the cooperatives relating to financing or raising the fund beyond the member, whatever the contribution member made in the cooperatives. Now, there can be a constitution of the various fund and the reserves, and I have talked with you relating to the reserve in my last lecture, and this particular reserve can be earmarked for a specific purposes, and or you can keep it just reserves open. So, whenever is required, you can use this particular reserve for the development or the growth of the cooperatives, or maybe starting a new venture, or maybe rewarding your members to a certain extent, or you can use it even for the purpose of starting a new venture or new subsidiary of that particular cooperatives. If there is a surplus, then you should have a specific provision in the bylaws relate how to handle that particular surplus or distribute that particular surplus, or at the same time if you are accumulating the bad loan, or you are accumulating the non-performing asset, then in that case you should know how to handle this, or what you should do with this bad loan or the non-performing asset. So, furthermore, you can talk about the mode of investment, and you can also talk about the custody of the funds. If the funds is not earmarked, or if you have raised that particular fund, or if you have got this particular fund because of the appreciation of the assets or some premium which you have get for at the time of issuing of the shares, or so much so forth. There can be a different source through which you have received this particular fund, and in that case you can talk about the custody of this fund. Now, you can make adequate provision relating to the membership, because membership is central to any cooperatives, and you should have a provision which is quite convenient to the members, because if it is not convenient to the member, then in that case possibly that cooperatives are no good for purpose of an organization. So, you can talk about the eligibility of member, condition for continuing the membership, how to obtain the membership, then withdrawal and transfer of the membership, then you talk about the termination, then you can take in what talk in what circumstances the membership can be seized, like the person can be insolvent, or person can be convicted for the moral turpitude. That means he has convicted for under certain criminal case under the IPC or some other kind of a financial offenses, then in that case his membership can be removed. But whenever you are talking about this particular membership, please remember to check the eligibility which has been prescribed by the Act, and you can add additional criteria with that particular eligibility, but whatever has been specified you cannot downgrade that particular eligibility. So, you need to check in the Parent Act whatever the eligibility has been provided. Now, then you need to talk about the nomination by the members. If you think that the members should come only through the nomination and they cannot come just by the open application, then you should mention the same. Now, the next important thing is member rights and obligations, and therein you need to talk about the rights and liabilities of the member. Then you need to talk about minimum performance expected annually of each member vis-a-vis the use of the service, financial commitment, participation in the meeting, adherence by the law, eligible to exercise this particular thing. So, what basically you need to talk in case of the cooperatives, that you cannot have a sleeping member. You need to have active member, and that particular member, even though not participating in day-to-day work of the cooperative, but he is acting in the policy framing, looking and monitoring the financial issues of the cooperatives, and so much so forth. Now, there can be a consequence of performing the below minimum level fixed. That means, if you find that while a particular member is not turned up for any meeting, that particular member is not fulfilled the commitment relating to his capital contribution or any other thing which you have prescribed, then in that case you might even suggest that this particular member will be warned, and after some point of time even his membership may be seized. Now, there can be consequence for default of payment. Now, as I have told to you that the general body is a heart of any cooperatives, because in my last lecture also I have talked with you that what are the matter general body can handle with, and we have seen that all the matter for that matter can be handled by the general meeting, and then I have said that residuary power actually left with the general meeting. So, if there is a board of directors in that particular cooperatives, then board of directors are basically delegated, power is delegated to the board of director by this particular general body. So, you need to carefully draft the power of the general body, because some of the power is already given by given in the statute itself, and if you wanted to give some more power, or if you wanted to set a further standard in the general body's activity, then in that case you need to define accordingly. So, you need to talk about the role of the general meeting and the subject which by default the general meeting is going to handle, and you can add this particular subject matter in addition whatever has been prescribed in the statute. Now, you can talk about the procedure relating to the conveying of the general meeting. You can talk about the procedure and the power of the general meeting, how it can be conducted. You can talk about the frequency of the general meeting, and as I have told you in my last lecture that in some of the law they talk about the frequency, and even they mention that which are the month this general body need to meet and hold the meeting. So, you can, if it is not mentioned in the statute, you can do that in this particular bylaw itself, and you can talk about the mode of summoning and conducting the meeting, and the right to vote, or how to cast the vote in the general body meeting. Then you can talk about the procedure of conducting the election in case of the cooperatives fail to do so, what will happen, and in that circumstances, if the general meeting has not been called by the management, existing management, then who has a right to call this particular general meeting. Then how to record the minutes of the proceedings of the general meeting, how it will need to be distributed amongst all the member of the general meeting. So, what are the disclosure measures you are going to adopt relating to transmission of the annual report and the audited account to all the general body meeting. You can have the procedure provided in the bylaws. You can further decide about the size of the board, how many people can sit in the board, and how those particular people can be elected in the board, and how many days they can continue in their office, can they be re-elected, or is it need to have a fresh election every year or every couple of years duration. So, you need to talk about this particular thing. Please remember, most of the cases you will find this is basically specified by the parent law. And now this there is a lot of talks is going on relating to that. Even people are talking about appointing the independent directors in cooperatives, but that particular concept is yet to be take a proper step in India, but maybe tomorrow that kind of situation might come, because please do remember, in India there is a many large cooperatives are there, and who basically provide a lot of service to the entire country's economy. I believe you are aware of the fact the largest cooperative which India have, which is known by everybody, is Amul. So, they do the innovations, they do lot of business, they add into the market value and all this thing. So, in those particular circumstances, you need to have expertise, you need to have a proper management, and people are talking and making a amendment into this particular thing. So, then again you have to talk about the quorum, you have to talk about the frequency of the meeting, you have to talk about the power, function and duties of the board of directors. You can also talk about if the directors fail to discharge their duty or observe the care and skill which they are supposed to do under the law, then what kind of penalties you can impose on them. Are you going to decapacitate them to be a member of this particular board, so much so forth. Now, you can also talk about who will what are the responsibilities of the duties of the chairman, vice chairman, treasurer, secretary, and how they show, or if there is a chief executive officer, how they will be appointed and what are the powers and duties they should discharge. Now, if there is a chief executive and the staffs are there, that means who are going to discharge more of executive function or day-to-day function, then in that case you can talk about the qualification and how he can be appointed, and how if he is not able to discharge the function, what is the removal procedure, then power, function and responsibility which he need to discharge. Then the penalties for acting against the interest of the cooperatives you need to talk about. Then you need to talk about authorization of the officials or officials for signing the document, because if you remember, I have started with that somebody has to keep the common seal. So, herein you need to make this particular provision that who is going to keep this particular common seal and who is going to create this particular common seal, because if you are entering into a contract outside with the outsider, then in that case you need to put your common seal there. So, you can declare out this particular thing, and if there is any legal proceedings which has been instituted by you, or you are instituting a legal proceeding against others in the court of law or in arbitration or mediation or wherever it is, then in that case it is better to designate a person who is going to look after those particular issues. Now, you need to talk about the finance. When you are talking about the finance, it is more about how you are maintaining the accounting standard, what is the auditing procedure which you are required to follow, how you are going to transfer the share or interest in the shares, what are the procedure you should follow relating to the redemption of the shares, then what are the procedure you should follow relating to payment of the interest, and if the person is deceased, then in that case how you are going to dispose his interest in that particular thing, particular shares. Then you need to talk about granting guidelines relating to granting of the loans. You are required to talk about the purpose for which the loan can be given, and so on and so forth. So that means there should be detail out relating to the policies of financial activities of the company. Then you can further talk about the rights, and if the cooperatives may confer on any other cooperatives or federal of the cooperatives, which of its member and the circumstances sign that particular right, and all those particular stuff. Then you can talk about mode of keeping the accounts in that particular cooperatives, and you can also talk about what are the standard you are going to follow as as a standard practice within your organizations. Or even if you wanted to talk about the internal auditing, if you wanted to talk about the periodical auditing, if you want to talk about the external auditing, then you can specify the procedure to that. Now, there is another matter which is important to mention into your bylaws. It is relating to the terms on which the cooperatives may deal with the organization other than the cooperatives. You can talk about the restrictions, if any, on the service of the cooperative society. Then you can further talk about the dispute settlement mechanism within the organization and outside the organizations, which can be sorted out even without going to the court or arbitration. So you can have some kind of procedure in place, or somebody can be given a charge to look after these particular issues. Then you can talk about the copies of the bylaws and annual balance sheet and the annual profit and loss account, how you are going to distribute to the members, or how you are going to put it in the public domain. And then if you wanted to have education or training program for your people into that cooperatives. Please remember, again I am talking about the cooperatives has a objective for social development. So in those particular circumstances, this is not for a profit making vehicle as we understand in case of the company, but cooperatives more you can make the profit, but it is more for doing self help, it is more for doing social innovation, it is more for addressing the social problem. So you should organize, you should develop the bylaws around this particular philosophy. Thank you.